it is kind of a pain. It is to register photos with the Copyright Office, but it is something that does give you a lot of leverage and power and negotiation and whatnot if someone does take your photo. It also, especially if you license your images and they're going to different people, people want to know that the people you're licensing the image to like to know that this is a registered image, that you are the actual owner of this image, and having a copyright registration provides that validation. You can do multiple registrations at once. You can do a bundle. The Copyright Office is going through some changes in terms of the rules and policies. So I don't remember exactly. It used to be you could register up to 750 images in one application for published photos, and it was unlimited for unpublished. And I believe now there's a cap on that. So I'd like to tell photographers that when they're done with their project, like they photograph a wedding, they've culled the images, they've edited them, they've put them off to their clients, take those images, and when they go to your client, you should also send them to the Copyright Office and register them together.
Right away.
Right away. I think it's a $55 registration fee. You do it once, you get used to it. It's kind of just a matter of practice. It's not too terribly difficult. And that way you know, and it's all done. That's one way to do it. Or the other way is you could register it after this infringement happens. But real quickly, the reason why you might want to register your images first before they go out into the public, before there's an opportunity for them to be infringed, for someone to take them without permission, is that when you pre-register like that, when you do it early, you do get more rights. You get more. If you did go to court and you win, you get your attorney's fees paid for. That's a big thing. But you have to have your images registered before the infringement happened. So you get your attorney's fees covered by the other side. You also get what's called statutory damages. This is the statute, the copyright law has a scaled set of money that you are allowed to get. Not no questions asked, but there is a minimum that you will get if you can go to court and prove your case and win. That's really helpful because if you don't register your images early and you do it, let's say after the infringement takes place, and you decide you want to sue and you win, you actually have to prove what's called actual damage. You have to show the court that this is what you lost on account of whoever used it without permission. And a lot of photographers don't license one image. A lot of them just do, weddings, and they charge a flat fee or something. They don't know what one image may be worth. And so maybe their damages aren't actually that high. You can also look at profits and whether someone profited off of it. But that may be difficult to show. That's what the issue, the LeBron James case actually.
I was going to bring that up. Yeah.
It has that issue. Is that basically this case that came out, a photographer took a photo of LeBron James. Then he put that on his social media.
LeBron did, yeah.
LeBron did.
Right.
And didn't have permission, supposedly, from the photographer or from whoever the photographer licensed the image to. And then the photographer sued, is my understanding, for copyright infringement. So the defense is that this was fair use, and that one of the issues was damages, that LeBron didn't make any money off of this photo. So if the photographer asks to get compensated by the profits that he made, it's zero. That's what he claims. But then, the other side of this is that anything that goes on to a professional basketball player's, social media page or any celebrity, there's a lot of value in those photos. Maybe it's hard to find the exact right dollar amount, but there is some profit being made by advertising oneself, especially when you're a celebrity. So that's one of the issues that came up. But